Greetings. I'm Carolyn Woodruff, CEO of Woodruff Family Law Group, and we're here today to talk about same-sex couples and domestic violence protection orders and the landmark case ME versus TJ that came down in December 2020. And we're here with an all-star group of panelists that have so much to offer. Before we get to the introductions, just a few ground rules for today. First, if you have questions for the panelists, please put them in the Q&A box and we will address those. If you were one of the persons who wrote an amicus brief or you are involved in the appeal to the North Carolina Supreme Court, please do not ask questions. We decided that it would not be appropriate for us to address the issues that are still under consideration by the North Carolina Supreme Court. So if you would honor those ground rules, it would be most appreciated. The panelists have been divided into time segments today, and we're going to try to stick as much as we can to those time segments. If at the end of the program of an hour and 15 minutes, there are questions that are not answered, if some of the panelists may stay on if you have more time. This is being submitted to the North Carolina Board of Law Examiners for CLE credit, which is pending at this time. You will be paying your own $3.50 per credit hour for that. So with no more ado, let's start introducing the panelists, and I'll turn to Christopher Brock.
Thanks so much, Carolyn. Greatly appreciate the opportunity to speak today. And to have the opportunity to talk about this important case from the North Carolina Court of Appeals. Carolyn, did you want me to introduce the entire panel or just go ahead and get us started?
No, we want to go through the entire panel and let them introduce themselves. Just state what firm you're with, what role you played in the appeal to the court.
It's Friday afternoon during a pandemic. I'm slow on the uptake. I apologize.
Okay.
My name is Chris Brook. I was the legal director of the American Civil Liberties Union in North Carolina from 2012 to 2019. I was a judge on the North Carolina Court of Appeals in 2019 and 2020. I'm now a partner at Patterson Harkavy law firm.
Thank you, Christopher. Sarah, give us some of your background and your role in this.
Hey, everybody. And Carolyn, thank you again for having us. I'm excited to be a part of this panel. My name is Sarah Saint. I'm an attorney at Brooks Pierce. I practice primarily in education law, but a lot of my pro bono practice has to do with LGBTQ rights. And I'm excited to be a part of this case. We represented several nonprofits serving the LGBTQ community, including Equality and C, and submitted an amicus brief in support of ME, in this case, at the Court of Appeals.
Thank you very much, Attorney Saint. Attorney McCool, let's hear from you.
Hi, thank you. Good afternoon. Thank you all so much for having us and for the participants for being here. My name is Emily McCool. I tell people it's just like family without the F. I am the attorney and owner at the Scharff law firm in Raleigh. And my role in this case was I, along with Elysia, were co-counsel at the trial court level and represented ME in Wake County District Court. And then I co-counseled with ACLU in the appeal at the Court of Appeals and the pending appeal at the Supreme Court. Thanks for having me.
Welcome. So Attorney Prendergast-Jones, introduce yourself. Then we'll get to Judge Burch and then let her take it over.
Hi, thank you all. I'm Elysia Prendergast-Jones, and as Emily said, I was co-counsel with her in the beginning of the case, and then we represented amicus to the Court of Appeals, and I am a supervising attorney at Legal Aid of North Carolina in the Raleigh unit doing family law and domestic violence.
Attorney Saint, what's your role?
I think we covered, but I can turn it over to Kathleen Lockwood.
Who's Lockwood? Attorney Lockwood.
Hi, I'm Kathleen Lockwood. I'm the policy director at the North Carolina Coalition Against Domestic Violence, and I'll be talking today about the impact of ME/TJ on some of our domestic violence agencies, court advocates, and survivors across the state.
So our first panelist that will be speaking is the Honorable Susan Burch, who has been a district court judge where I practice in Greensboro, recently retired, and was just an outstanding judge in all respects for the entire 20 years she was on the bench. Judge Burch, I'm going to let you introduce and say your role in this, and then continue with the panel up until 12:30. You have to unmute.
See, when you retire and you get old, you can't handle the technology. That's what it is. I'm Sue Burch. I was a district court judge in Guilford County for 20 years. I did retire just in December, and I spent most of my time on the bench working in civil court, family law cases. And I think over the 20 years, I had some experience and involvement in working out court processes, working on the different forms. And then when we would get new legislation, we would contemplate how to turn that into action for the individuals actually coming into the court. And so this was a really interesting case to me, and I'm very happy to be a part of this panel. I really appreciate, Carolyn, you putting all of this together. I think my role as this is to just do an overview of the case, and that would get everybody sort of some of the basic information that underlies the arguments and the parts of the case that make it so interesting. The case originated in Wake County in May of 2018, and the plaintiff in this action is identified by the initials ME. The plaintiff was self-represented when she went to the court, to the clerk's office, and she was seeking domestic violence protections against the defendant, who's identified in the action as TJ. The plaintiff indicated that the parties had been in a dating relationship, and the allegations from the plaintiff were that there was domestic violence between them on their breakup of the relationship. So the 50B forms, Chapter 50B is the domestic violence provisions for us, and we have state created forms, and they were created and modified over the years really to make them accessible to self-represented individuals. And if you look at those forms, the form complaint, one of the first provisions that it has after you get the caption information entered is to look at the relationship status of the parties involved. And that's because Chapter 50B in its language creates a classification for the types of relationships that are eligible for relief under the statute. And essentially that relief is limited to individuals that are in a class, and they define it as spouses or former spouses, household members, former household members, parent, child, grandparent, child. Then there's a provision that says for people that are in dating relationships of opposite gender. And the language is there in the statute. It's clearly intentional language. It's put there by itself. It's been there, I think, since the creation of the statute, and has not been amended. So when the plaintiff filled out this form, both the plaintiff and defendant are women, they're of the same gender. And so when the plaintiff filled out this form, that provision really didn't apply, but the indication was that they had not been living together. So that would have been the classification that the plaintiff would proceed under. And so the plaintiff filled out those forms. There's an indication there was some communication with the trial court, and that the judge at the ex parte level said, based on the way this law is written, you have to be of opposite genders to be eligible for this kind of relief. And in both the 10-day hearing and the ex parte hearing, there's indication from the court that the merits of the case, that they found merit in the allegations, but the concern about the granting of relief went straight to the classification of the relationship. So there's a procedural issue in how the case arose, and that is that after the plaintiff filed the action, there's some indication in the record that the the plaintiff talked to a judge, and then the plaintiff prepared a 50C action, which provides some no contact relief, but it is not as robust as Chapter 50B. It's not designed for the same type of case or same type of relief. And then at some point that morning, the plaintiff filed a voluntary dismissal of the 50B action, and then shortly thereafter filed a statement retracting that dismissal, indicating that the plaintiff did not want to dismiss the action. The plaintiff wanted to go forward on the 50B action. And so the matter went back to the court for ex parte. The ex parte judge found that the relationship didn't meet the criteria, denied the relief based on that. And at the 10-day hearing, the trial court essentially found the same, made indications that there appeared to be merit to the claim, but that the specific language of the statute excluded parties of the same gender who were in a dating relationship from seeking that kind of relief. So trial court denied the request. The Court of Appeals, in the panel was Chief Judge McGee, Judge Bryant, and Judge Tyson. And the Court of Appeals considered the challenge by the plaintiff on the issues of due process and equal protection, both under the 14th Amendment and the North Carolina State Constitution. And then spoiler alert, I'll just go right to the end of it. They found that 50B does not survive the challenges in that measure. Chief Judge McGee wrote the opinion, Judge Bryant concurred, and the appellate court reversed the trial court dismissals. Judge Tyson's dissented in the matter, and the subject of his dissent is that this procedural issue with the dismissal and then the filing a retraction of the dismissal divested the trial court of subject matter jurisdiction. And so that's kind of the nutshell overview of it. And I think that the panelists will flesh out the case a lot more with the various arguments. There's, this case really could be an entire semester's worth of constitutional law. It's a great way to study the application of all of these principles. And so I think I did pretty good. I got that to 6 minutes, and there you go. There's your overview. See, now Carolyn's muted. Now I'm not going to call Carolyn old, but we've been practicing together for a long time. So
outstanding summary, Judge Burch. Now we're going to turn to Attorney Sarah Saint for her comments.
Judge Burch, thank you for that wonderful summary. And I think at this point, since you've done a wonderful job outlining kind of what happened at the trial court level, that makes sense for Emily to talk about in more detail what was going on at the trial court level. And then I'll hop in with what the arguments were from the LGBTQ nonprofits.
Great, thanks, Sarah. And again, thank you, Judge Burch, for kicking us off and providing that overview of the case. And I also, not to make it a big love fest, but I just want to express again my gratitude also to just these fabulous co-panelists who have been on this case and working on behalf of ME and those similarly situated to her for almost 3 years now in some capacity, either themselves or their agency. And I just, for me, this is why we become lawyers is, as Judge Burch said, you could have an entire a semester talking about the constitutional issues and things, and to be, fighting for ME and those similarly situated on a case like this, and to use law to be able to help those and provide safety and protection for people who are victimized, and to make sure we have constitutional protections for people who are marginalized and oppressed is really why we're lawyers. So I just am really grateful to be a part of this team and to be a part of this case. And so thanks for having me on this panel, and thanks to my esteemed colleagues for all their dedication. I, is sort of talking about this case from my sort of job. I think we talked about in this webinar before handing it over to some of the constitutional issues is to dig a little deeper into what Judge Burch actually mentioned about the framework and our statutory framework, and how it applied specifically to ME's case, but also to all those who are similarly situated to her. As most of you maybe already on this call know, but to highlight the difference here in North Carolina, that we have two main pathways to a protective order in North Carolina. We have our 50B statute and we have our 50C statute. And our 50B statute was intentionally designed for intimate partner violence. That is what it's there for. It was the design and intent to protect those who were in an intimate partner relationship. The remedies are such to be able to address intimate partner violence, and as opposed to 50C, which actually is explicitly designed to not include intimate partner violence. And the remedies that are created around 50C do not consider the different types of problems and power and control dynamics and the different lethality that folks encounter when they're in an intimate partner relationship. Of course, what we know, since we're here in this case, and if you do this work, is that unfortunately, despite the overall intent of 50B, the language of 50B and 50B-1B6 with its opposite sex language explicitly carves out one section of our population here in North Carolina and says that everyone, that's in an intimate partner relationship deserves protection except this specific category of folks. And so if you are in a same-sex dating relationship and haven't lived with your partner and are a victim of domestic violence, then that 50B protective order, whether or not it's available to you is not clear by the statute, and that language excludes you. And so 50Z, that'd be new. A 50C does not adequately provide protection. So what happens to our survivors in these same-sex relationships when they don't feel like they can apply for a 50B, or they try and are denied, and then there's sort of spill over into a 50C, that a 50C, which was specifically for people not in an intimate relationship, for folks who are stranger sexual assault, stranger stalking, it doesn't meet their needs. And so that was exactly the case for ME. Specifically, right, in ME's case, there were a couple of ways that this directly impacted her, that she was not able to obtain a 50B at the trial court level. So for instance, in ME's case, ME talked about in her complaint and at the trial court level that TJ had access to firearms. And we know from intimate partner violence and from research that the presence of firearms and access to firearms in conjunction with intimate partner violence is a lethality factor, that victims of domestic violence are at more risk of being lethally harmed if their abusive partner has access to firearms. That is why the 50B statute has that remedy, a remedy to have the defendant, the abusive partner, surrender firearms, be prohibited from purchasing or possessing firearms. But that same remedy is not available in a 50C. And so while ME was denied a 50B and was denied that possible remedy, ME did get a 50C at the trial court level. It was one consented to by TJ with findings of fact that would otherwise support a 50B. But nonetheless, that 50C does not allow for the granting of removing of firearms. And I can tell you this was particularly concerning for ME, that TJ continued and continues to have access to firearms. In addition, one of the other huge differences between 50B and 50C that again directly impacted ME and continues to is the level of accountability and enforcement between 50B and 50C. That 50B was designed to have the power and enforcement of the state. In fact, in all of our statutes, 50B violations are the only place in North Carolina statute that has mandatory arrest provisions, such that if law enforcement has probable cause to believe a violation has occurred, the statute says they shall arrest. Everywhere else, law enforcement has discretion, but not with violations of domestic violence protective orders, because again, we know that that is a lethality factor. That victims are more at risk if you have an abusive partner who is willing to and is violating court orders. And as opposed to a 50C that we know is much weaker and much harder to enforce, and in fact brings the survivor back more in contact with the abusive partner, puts the burden on them to file more paperwork, go back to court and have direct contact with the abusive partner. They may or may not be able to afford or get an attorney to help them in that procedure versus a criminal charge from a violation of a 50B where the state picks it up. And in this case, although ME got a 50C, TJ on more than one occasion was violated that 50C after she got it. And after a lot of discussion with ME, we decided to not file contempt process for those reasons, because of the actual trauma that it would induce for ME to have to go through that process of go back to court, see her abusive partner in court, and the very little remedy and enforcement that she would get, even if that 50C contempt was found. And so again, you have such a difference between 50B and 50C, which takes me to my final sort of point that I want to talk about in my last couple of minutes before I turn it over to Chris, about the importance in this case and in any case, if you're doing this work, and I imagine most of you, if you're on this call, are probably doing this work, is the importance of trauma-informed lawyering. That it just cannot emphasize enough the importance of getting those skills of trauma-informed lawyering if you're doing work with survivors of domestic violence or sexual violence or stalking, and if you're doing work with folks who identify as LGBTQ+. There's, I don't have time in 2 minutes to talk to you about trauma-informed lawyering. There's lots of wonderful trainings out there right now, and webinars and in-person trainings. So I'd encourage you to check those out. But I will tell you that my work with ME has been so grounded in trauma-informed lawyering. This process, as Judge Burch mentioned, started in May of 2018. It has been going on for almost 3 years now. And I can tell you that it was both initially traumatic for ME, and it continues to be re-traumatizing for ME the longer that this case goes on. I remain in regular contact, obviously, with ME to support her through this. This has been an extraordinarily drawn out appeal. And for as long as it goes on, it continues to impact her and impact her daily life. She, deserved that protection in May of 2018. And she continues to be in fear of TJ, continues to be in fear of continued contact from TJ, of the fact that she has not been and still is not afforded the protections that she deserves from a 50B, that is her constitutional right. And that I think there's really no dispute is her constitutional right. And so I just can't emphasize enough the importance of learning those trauma-informed skills and being able to support your client through that trauma. But speaking of constitutional rights, I am happy to turn it over. I think that's my 10 minutes. I did it. I'm going to turn it over to Chris and let him sort of talk more about the constitutional issues that were addressed at the Court of Appeals.
Thanks so much, Emily. I really appreciate it. And thanks again, Carolyn, and to the Woodruff Law Firm for this opportunity to speak about this important case. Thanks to everybody who's taken some time out of their Friday afternoon to join us. Not to be glib about it, but it's March Madness and we're in North Carolina. So this is like a big deal that you're taking time. And I think it's because it's such an important case. As Judge Burch very aptly said, you could teach an entire semester of constitutional law based on this Court of Appeals opinion, and I'm going to try to cover it in between 5 to 10 minutes. And most of the people who are on this webinar know that I am exceedingly long-winded under the best of circumstances, so this is like a physical challenge for me. So we will see exactly how this goes, and I assume that Carolyn will throw something at me through the screen if I'm still talking at 1:15. So I'm going to briefly summarize the substance of the Court of Appeals majority opinion. But before I do that and drone on and on about constitutional law, I do want to make what I regard as the most important point, especially as I know there are a number of legal aid of North Carolina attorneys who handle domestic violence cases in court on a day in, day out basis who are joining us today. So first, thank you for the work that you do. As Emily very aptly summarized, it is exceptionally important work. You know far better than me that DVPOs can save people's lives, preventing what are already bad situations from getting worse. So I just want to, y'all are underthanked, Legal Aid of North Carolina as a general matter, but I want to make sure that you're thanked during the course of our discussion today. Y'all also know far better than me that domestic violence plagues the LGBTQ community just as it plagues the straight community. This is not a problem that exists only in one community or only in one type of relationship. There is a real need for domestic violence protective orders for folks who are in same-sex relationships. So that's the point that I want to start with, is though this matter is on appeal to the Supreme Court related to procedural issues, MEVTJ is the law of North Carolina until a higher court says otherwise. You can be using this opinion to ensure that folks in same-sex dating relationships who do not live with their abusers receive domestic violence protective orders, receive 50Bs when the circumstances merit. The Chief Judge McGee's opinion is sort of explicit about this, and it says, the provision, if the provision at issue is unconstitutional as applied to the plaintiff ME in denying her request for a DVPO, then the denial of the protections of Chapter 50B to any similarly situated plaintiff would also be prohibited. So I want to start with that point, that this is the law in North Carolina today and will remain the law in North Carolina until a higher court does something to the contrary. So I want to blast through Chief Judge McGee's majority opinion, and she refers to what her analysis as full 14th Amendment review, and that the center of that review and the tentpole of her analysis is the same-sex marriage decision in Obergefell from the Supreme Court of the United States, which in turn builds on Windsor, on Lawrence, and on Romer versus Evans' previous LGBTQ rights cases. It centers not only on Obergefell, but also on Obergefell's recognition of the interrelation between the 14th Amendment's due process clauses and due process clause and equal protection clause. So boiled down to their sort of most essential, due process prevents the government from arbitrarily deciding which classes of people may enjoy constitutional protections of their recognized fundamental rights. And equal protection mandates that similarly situated people are treated similarly. But one of the central teachings of Obergefell that is picked up on by Chief Judge McGee's opinion is that the protections of due process, the guarantees of due process, the guarantees of equal protection oftentimes overlap, in particular in regards to the LGBTQ community. So the opinion highlights the number of fundamental rights that it asserts are implicated by the denial of a domestic violence protective order in this instance. talking about personal safety, which Emily talked about at great length, autonomy, identity, dignity. Again, all of the ideas wrapped up in that people are allowed to make intimate partner choices consistent with who they are, and they should not face an unequal governmental treatment based on those choices or arbitrary governmental treatment based on those choices. Given the fundamental rights that are implicated were implicated by the denial to ME of the Domestic Violence Protective Order, which again, as Emily noted, everyone agreed that there were facts to bear out that domestic violence had occurred in this instance. Strict scrutiny was applied by the Court of Appeals majority. And the standard for strict, and just again, to take you back to constitutional law class again, to a certain extent, when strict scrutiny applies, the governmental classification is almost always going to fail. But strict scrutiny demands that the classification be necessary to advance a compelling government interest, that the classification be narrowly tailored and use the least restrictive means to realize that compelling governmental interest. So applying that exacting standard to these facts, the Court of Appeals said this classification is rooted in historical animus towards people in the LGBTQ community, people in same-sex relationships. But not only that, this classification not only does not further a compelling governmental interest, but it actively undermines the statutory scheme that's at issue here. The statutory scheme at issue here is about protecting people from domestic violence, and this runs entirely contrary to that. The Court of Appeals majority also highlights, on the other end of the analytical spectrum when you're dealing with due process and equal protection, is rational basis review. Rational basis review is exceptionally deferential to governmental classification. All it requires is that the classification be rationally related to a legitimate government interest. So where strict scrutiny is generally fatal to the governmental classification, rational basis review is almost always going to uphold the governmental classification. Chief Judge McGee's opinion, however, goes out of its way to say, this does not even pass rational basis review. The classification here, given that it undermines the state's stated interest in preventing domestic violence, can't even satisfy this unbelievably deferential standard. The other two things that I want to note, because I do know that I'm coming up on my 10 minutes here, that's sort of the fundamental tent poles of the Court of Appeals opinions, but I think they're opinions. But there are two things that merit mention beyond that. First, there is a parallel, what I did there was more or less a federal constitutional analysis, but the Court of Appeals majority also conducts a parallel state constitutional review. The state constitution has a due process clause. It's called the Law of the Land Clause, guarantees equal protection as well. The federal constitution sets a basement below which states cannot deviate, but not necessarily the ceiling. So the court also did a state constitutional review and found these classifications and the denial of the 50B fails state constitutional review as well. And then the final thing worth noting is that during the course of the pendency of this case at the Court of Appeals, the United States Supreme Court decided Bostock. Bostock was a Title VII opinion, which centered on the prohibition on employment discrimination, quote, because of sex. In an opinion authored by Justice Gorsuch, said that discriminating based on sexual orientation or transgender status in employment decisions necessarily entails discrimination because of sex. The Court of Appeals opinion applied that view of sex discrimination in the 14th Amendment context. Oftentimes constitutional and statutory analysis inform one another. The 14th Amendment has been interpreted to look very skeptically at sex discrimination as well, applying at least intermediate scrutiny to sex discrimination, which is an important governmental interest by means substantially related to that interest. So they found, the Court of Appeals, that this was also, per that logic, sex discrimination that was unconstitutional as well. So in sum, as applied to individuals in same-sex dating relationships, this provision of the Domestic Violence Protective Order statutes was held to transgress both the state and federal constitution's guarantees of due process and equal protection. And I do think, Carolyn, that that was less than 10 minutes. So I probably sounded like the Micro Machine Man during a lot of that, but wanted to make sure I got through all of that.
So let me just say this, if you're here and you want us to submit your name to the bar for credit, please put your name and your bar number in the chat box between now and the end of the program. So you, Chris, who did you decide would go next? Attorney?
I think Sarah Saint is going to go next.
All right, great job to all of you so far. Wow, impressed. Sarah Saint?
Thanks, Carolyn. So again, I, with Eric David at my firm, have the honor and privilege of writing on behalf of LGBTQ nonprofits, folks that serve the LGBTQ community. And I've worked with these organizations for a long time. And as Chris stated, we see that intimate partner violence impacts the LGBTQ community just as, if not more than, the heterosexual community. And so we argued in our amicus brief that because this is such a big issue for the LGBTQ community, and because the purposes of Chapter 50B is simply to protect folks from domestic violence, that there's absolutely no rational basis for excluding members of the LGBTQ community from obtaining domestic violence protective orders. And so we spent a lot of time talking about the constitutional issues that Judge Brook just covered, so I won't go back through those, but I do want to highlight the ways in which that the LGBTQ community is impacted by intimate partner violence. There is ample empirical and anecdotal evidence that indicates that the dynamics and prevalence of intimate partner violence is the same, if not worse, in the LGBTQ community. While it's unique from couple to couple, it spans the gamut of intimate partner violence, everything from physical violence to verbal abuse to coercion and threats and intimidation, emotional abuse, financial abuse, psychological abuse. If you can think of it, it occurs in the LGBTQ community. But additionally, there's an extra weapon that same-sex partners have to use against their partners in domestic violence situations, and that's outing their partners. A lot of folks in the LGBTQ community are not out to their families, they're not out to work, they're not out to friends, and they may be in an intimate relationship, but not yet out to different areas of their life. And so folks don't know that they're in this relationship, or they don't know that they are a member of the LGBTQ community. And so an additional weapon that same-sex abusers can use is sharing that information with their families, with their workplace, with their friends, in a way that can damage their relationships, in a way that can take them away from their job. Chris mentioned the Bostock decision and how that means that Title VII now applies to folks that are discriminated against because of their sexual orientation. But what a lot of folks don't know is that it only applies to employers with 15 or more employees. And so if a member of the LGBTQ community works for a smaller employer, they can still be fired simply for being gay. And so this outing weapon is a very powerful one. So additionally, and on top of all the ways that domestic violence can occur for folks in same-sex relationships, it's also more frequent. The CDC has reported that the lifetime prevalence of rape, physical violence, and stalking from an intimate partner was more than 40% for lesbian women, more than 60% for bisexual women, compared with only 35%. I say only, that's still a huge number, but 35% of heterosexual women. Similarly, with men, heterosexual men face intimate partner violence at a rate of 29%, where bisexual men, it's as high as 37%. Further, gay men are more likely to experience physical violence than any other subgroup, including straight women. And so, you know, this is a serious problem in the LGBTQ community, and I have unfortunately encountered it in my own work and working with LGBTQ nonprofits. But unfortunately, on top of it being a huge problem, there's a whole lot of barriers to folks finding help. One of those barriers I just mentioned is that a lot of people aren't out to people that they trust. And so finding a person that you can call and say, hey, I need help and I don't know where to go is limited for folks in the LGBTQ community. There's also very few shelters and services that serve the LGBTQ community, and even fewer that serve exclusively the LGBTQ community or explicitly the LGBTQ community. And so this leaves that only about 27% of LGBTQ survivors of intimate partner violence actually seek help from emergency shelters and social services. And this is because they have been turned away from a lot of these organizations. And that's why the work that Legal Aid and the North Carolina Coalition Against Domestic Violence is so important, as they serve as a lifeline, as Emily was saying, to folks who don't have a lot of other places to go. This is especially true of gay men, that there are so few shelters that serve men and even fewer ones that will accept gay men who are victims of intimate partner violence. Another issue is that there's a policing issue. Folks in same-sex relationships that are dealing with intimate partner violence have a severe distrust of the police. And one of those reasons that a lot of arrests that happen when police are called to a same-sex abusive situation is that the police arrest the wrong person or both people. And so a lot of times the survivor is being arrested when they're the ones that were being abused in the first place. And this is, I mean, it does not happen at low rates. I'm talking the 30-40% rates that the police are arresting both people or the wrong person. And so Chapter 50B becomes this really important lifeline to folks that are in same-sex dating relationships that are facing abuse, and that they don't, you know, until the Court of Appeals decision came out, didn't have access to it, is shocking to a lot of folks, and important that this work was being done to get them access to that lifeline. And so, as Chris mentioned, we've been on a federal trajectory to providing more and more rights to LGBTQ folks that are commiserate with heterosexual folks, starting with Romers v. Evan in 1996 and going through Lawrence and Windsor and Obergefell, and then, as Chris mentioned, into the Bostock decision in 2020, which again protects a whole lot of folks, but it doesn't protect everybody. National and governmental agencies are also calling for these protections. In 2015, the ABA passed a resolution urging state governments to enact civil protection order statutes regarding intimate partner violence for folks and for the LGBTQ community. Similarly, the CDC recommends that states pass laws explicitly protecting the LGBTQ community, because this is such an important issue that is impacting folks across the country. And in fact, until the Court of Appeals decision came out, North Carolina was the only state in the country that didn't have these protections, that didn't protect same-sex or victims of same-sex dating violence the same way it protected victims of opposite-sex dating violence. So in some, the arguments that we put forth to the Court of Appeals was that domestic violence permeates intimate relationships regardless of marital or cohabital status, sexual orientation, or familial relationship. And discriminating against victims of same-sex dating violence unconstitutionally denies them due process and equal protection of the laws, and cannot stand even under a rational basis test. And therefore, we were thrilled to hear that when the Court of Appeals decided this, that the law is unconstitutional as applied to Emmy and to other folks similarly situated to her.
That was really great, Sarah. Thank you very much. So which of the two of you would be next? On my list, it would be Mrs. Prendergast-Jones.
Yes, thank you. I want to thank everybody again, just as everyone said, for joining us and for inviting us to this panel. Again, this is something that it is dear to me. I did start it with Emily, in this case, the ME case, but it is also dear to me because as a legal aid attorney, this is what I do day in and day out, just as my colleagues and those of the coalition and PISCA. So it is personal. And what I'm going to go through is explain to you how those survivors get to an organization like us, and explain to you why it's so important for this case. Because ME came to us after filing on her own. And most of the people file on their own. You don't have help when you're going into the courthouse. You don't know what to put on the piece of paper. You don't get instructions. What happens is you get a piece of or package of paper, and the clerk tells you fill out all these paperwork and give it back to us, or ask you what your relationship is to the party. And then they direct you which is appropriate, whether it's a 50B or a 50C. And that's exactly what happened in here. In this case, what happened was exactly that. The clerk asked what the relationship was between the parties and ME. The clerk directed which was the appropriate paperwork to fill out. When they decided that maybe this wasn't the appropriate paperwork, they directed ME to fill out a 50C rather than the 50B. ME had already filled out the 50B. But going towards a little bit fast forward to that, that's how everyone goes through it for the most part. It is very rare that a survivor will have the assistance of an attorney going forth in those initial stages to help with drafting of the paperwork. When they go in, they are usually seeing a magistrate or a judge on their own filling out that paperwork, depending on which county they are in and the rules of that county. So then they are seeing that judge or that magistrate for the first time on their own, filling out that paperwork, trying to do the best that they can to fill in the blanks in a high crisis, usually frustrated or really flustered state, because that's the time where they finally decided that this is the time that I can fill it out. I have the time, or I'm fleeing for sometimes the 7th, or, you never know what time it is. That final time they've decided to do it, or the time that their children are in school, or the time that they finally were able to get away, or the time that, it was that final black eye that they couldn't get through that they did. So they're in crisis at that time that they were going in there. So a lot of times they're not even thinking straight. They can't even put down or articulate all of the words that they want to put in there. So doing all of that in a high pressure intensive state, drafting it on legal terminology that they have no idea. So they're all doing that, putting that down. And that's where you start off. Then they're filling out those paperwork, talking to a judge, explaining their case. While they're doing that, that case then goes to a magistrate or a judge, depending on, again, on the county. Once that is either decided for court or the ex parte is granted, then they will seek services, if they know about it, to a agency such as legal aid, or an agency which in Wake County we have Interact, but there are other counties, like in Jackson County we have Harbor, which are agencies that help survivors with getting resources. So what happens in those cases, they will send out information, they will contact those agencies, and those agencies will help them send their paperwork to an agency such as ours, Legal Aid, to get them connected with an attorney so that the attorney can assess their case to possibly represent them in the matter. So all before that time, they are pro se, considering they are representing themselves. And legal aid is an organization that comes in at the last minute, right before they are preparing for their final hearing or their permanent hearing. So they are either connecting through, they call our central intake unit, or one of coalition's central intake unit numbers or hotline to get connected to an attorney, or even searching for a private attorney at that time. So this entire time, they are on their own filling out the paperwork. So many times that paperwork may need to be amended because they're left out, or they don't know what to do, or they're guided by the judge. So one of the things that this is really important to us, and this ME is important, is because of the fact that you can't put so much pressure on that pro se person that comes in without the guidance of knowing that legal background and expecting that person to understand all of the things that an attorney and a judge would understand, because they don't get the benefit of having legal representation. So in this case, Emily and I didn't step in until the last minute, right before that person, was going in front of a judge at that last minute. And then it's still a heightened situation, because then they're still in that midst of trauma. So then you can't think as well. We're still trying to help them, but they're still in that midst of trauma. And you want to make sure that you're helping guide them through that midst of trauma. But that is when we step in. So I wanted to really emphasize the fact that this whole thing is pro se for the most part when people are doing this. And I believe I don't want to go over my 10 minutes, so I think I may be up, but I really thank you all.
Beautiful comments. Thank you very much. So with that, remember to put your name and your bar number in the chat room so we have that attendance record for the state bar. So Ms. Attorney Lockwood, let's hear from you.
Hi, thanks so much again, Carolyn and Judy, for putting this panel together. I'm the caboose, so hopefully I won't be too repetitive, but I wanted to highlight some things that the other panelists have said and add a little bit more to the conversation. So as I said in the introduction, I'm the policy director at the North Carolina Coalition Against Domestic Violence. Before starting in this role, I was a staff attorney at the coalition for about 3 years. And in that position, I represented survivors in domestic violence court in Orange County, which for the most part translated into representing plaintiffs in domestic violence protective order cases. So I'm bringing kind of both of those experiences into my remarks today. So the North Carolina Coalition Against Domestic Violence, for those of you that aren't familiar with our organization, is a statewide nonprofit. We are a member-based organization, and a large majority of our members are domestic violence agencies that provide those direct services like hotlines, shelters, and court advocacy services to domestic violence survivors experiencing domestic violence. We also provide training and technical assistance to other members and community members who are allied professionals helping survivors of domestic violence, such as attorneys, if you ever need us for that. Our goal and mission is to end domestic violence. And one of the ways that we do that is through training opportunities that we offer. We have an Advocates Institute that focuses on the dynamics of domestic violence and kind of all the competencies and skills needed to serve survivors in whatever capacity an individual is interacting with the survivors, either professionally or personally in their lives. And we have a specific training for legal advocates. And I'm going to talk a lot about legal advocates in my remarks today. Those are non-attorney advocates working at domestic violence agencies that are often providing legal information to survivors who are just contacting the agency to learn about what options may exist under North Carolina law to address their situation. And like I said, they are non-attorneys, so they're providing legal information and not advice. So through our kind of purview at the coalition, there are a few things I wanted to highlight that Sarah had also mentioned that are specific to the LGBT community as survivors. There are distinct barriers that they're facing in accessing services, regardless of what North Carolina law says. But the law that's at issue in MeVTJ really exacerbated that prior to this opinion. One that Sarah really artfully laid out for us is the fear of outing. And because of that opposite sex requirement in the dating relationship requirement under personal relationships, our court forms, as Judge Burch mentioned, do require folks to list what their sex is on the form. And that is an outing experience both for same-sex partners or for trans partners, because they have to identify what their sex is and the sex of the defendant. And that creates such a huge barrier that many folks in that situation feel like they cannot access domestic violence protective order relief because the fear of outing is too big of a burden to overcome. Another barrier is just the experience of homophobia within the court system itself, either through interactions with domestic violence service providers and court advocates, which at the coalition, like I said, we're working really hard to prevent from happening moving forward, but also just interactions with court officials like clerks, attorneys, and judges who may not have the competency or might not be working underneath laws that give them the ability to interact with LGBTQ survivors in a way that doesn't re-traumatize them through their experiences of homophobia as well. And then, as we've talked about multiple times throughout this panel, North Carolina has the distinct displeasure of being the last state in the country to fully expand domestic violence protective order relief to all LGBTQ survivors in our state, which, knowing that that is the case, prevents a lot of survivors in the LGBT community from even interrogating whether or not they may have fallen underneath the other umbrellas of relief that they could have found under the personal relationship definition. So a piece of our work, in addition to this training and technical assistance that I mentioned, is lobbying the North Carolina General Assembly to pass laws that benefit survivors and work towards ending domestic violence. And a big part of our legislative agenda for many years has been trying to figure out if there's a way to close this coverage gap in North Carolina through removing the opposite sex language in our statute. To get us kind of to where we are today, I wanted to zoom all the way back and give a little bit of a history of what the personal relationship definition has looked like in 50B throughout the years. So when 50B was initially passed in 1979, it explicitly only covered personal relationships that were current or former spouses or individuals of the opposite sex who had lived together as if they were married. And that really reflected the state of understanding culturally about what domestic violence was at that point. And since that time, there have been changes and additions to that personal relationship definition. So in 1997 was the next large change to that definition. And that's when the General Assembly added that provision that is at issue in the as applied challenge in METJ, saying that opposite sex dating relationship partners could be covered. And obviously, that does not cover all relationships in North Carolina, which is why we're on this panel. But at the same time, as is mentioned in Virginia Hager's question in the chat, the legislature also added the category of current or former household members. And that was kind of the beginning of little carve-outs that LGBTQ individuals over the years could use if they had lived in the same household to get a DVPO. The next kind of expansion of categories that could be used to provide more access to LGBTQ individuals is with the passage of same-sex marriage nationwide and same-sex marriages being an option in North Carolina, which happened 2014, 2015. At that point, not only could LGBTQ individuals marry their partners, but they could then at that point have coverage under DVPO as current or former spouses. That also led to same-sex partners being able to adopt children together, which allowed them to then get DVPOs if they had a child in common with their abusive partner. But through all of these kind of carve-outs that we had to use legal arguments to cover for the LGBT community, the major coverage gap remained of the opposite sex language passed in 1997 applying to dating relationships. So that kind of brings us to where we had all the constitutional arguments that Chris really artfully laid out for us in MEVTJ. And despite the fact that a lot of the case law that formed the basis for that argument happened in 2015, our legislature was not interested in closing that loophole through statute prior to the passage of the publication of MEVTJ in the Court of Appeals. So less than a month, though, after the publication of MEVTJ, 3 Republican House of Representative members in the North Carolina General Assembly did file a bill to address explicitly this problem. This is House Bill 33, and the Republican sponsors are Representative Zachary, Representative Warren, and Representative Moffitt. And this bill removes all references to opposite sex in the personal relationship definitions in 50B1. This bill's been assigned to the Judiciary 3 committee, so it's still very much in its infancy in the General Assembly, but we're looking for a soon, hopefully, a hearing and a vote in that committee so it can keep moving along the track, because it's important to us that the statute match the current state of the law. Because as we mentioned through Elysia's comments, the survivors are often coming in pro se or with a court advocate from a domestic violence agency. They're relying on the legal information that they see on court forms and in statute often to understand what their eligibility may be before they even approach the courthouse to fill out that paperwork. And as Elysia said, the survivors often aren't even connected with an attorney at any point of the court process. So we want to make sure that the legal information is very consistent and clear in North Carolina, that we recognize all survivors of domestic violence, regardless of their membership in an LGBTQ community, should be covered under DVPO to get relief. And just kind of to close, it's important that this Court of Appeals opinion was laid out the way it was because it benefits all LGBTQ survivors, those that have an attorney and those that don't have an attorney, by clarifying that every survivor across the state is entitled to full protection under DVPO laws. It also allows those non-attorney court advocates to have a clear reference and clear legal information to provide survivors about what their options are under the law. And above all else, it ensures that LGBTQ individuals in North Carolina are no longer discriminated against in the mere definitions of domestic violence in our law, much less in their application. So I'm not sure I got us to the 10 minutes, but I did get us to the Q&A portion. So Carolyn, if you'd like to take it from here.
Thank you so much to our all-star panel. If the audience has questions, if you could put those in the Q&A box, and if you could also in the chat box put your full name and your state bar number for the credit, that would be just fabulous. So here's a question for Amelie. You mentioned trauma-informed lawyers. Where do we become trauma-informed lawyers? How do we do that?
Sure. So thanks for that question, Carolyn. So there are more and more trainings and availability these days about trauma-informed lawyering. Like the North Carolina Advocates for Justice last year hosted an all-day training that I participated in as one of the trainers. And I know that sort of just searching, there are webinars. The Victim Rights Law Center does a lot of webinars, as well as the American Bar Association has a domestic and sexual violence section that does webinars as a good place to start. There's also an agency that you can go to online, and I can try to put some of these in the chat. That's the National, I think I always get the order wrong, but I think it's the National Domestic Violence Mental Health and Trauma Center. Kathleen may know it as well. I know I worked at it as well. No, okay. But they have a lot of resources online to read about. So there's just a lot more resources out there about trauma-informed lawyering. And so I would just really encourage folks to do some research and hop onto those trainings where they're available.
So this House Bill 33, what does it provide, and is it getting traction?
So as it's filed, a bill gets filed and it can change all its colors before it becomes a law. But at the current state of affairs, all it does is remove all opposite sex language. So just cross out the words opposite sex in the personal relationship definitions of 50B1B. We are not yet at the point in the life of this bill to know exactly how much traction it's getting. Obviously, the fact that it's not in rules is a start. It tells us that it could be moving forward, but it's still so early, and the committee conversation has not yet happened in public for us to know exactly where all the legislators fall. But it is promising that it has 3 primary sponsors that are all Republicans, given the party makeup of our legislature at this point. So we're closely following it at NCCADV, and just remember House Bill 33, if any of y'all have your own legislative bill trackers that you'd like to put that in.
So I'm curious on something Attorney Saint said about using this as an outing weapon. Judge Burch, did you see people before you using those kind of things as outing weapons that you could identify, or is that just subsurface and something that's very hard to dig down into and see?
No, over the 20 years, I can recall a couple of people that when they realized that this was filed and it was going to be sent out to the other side and that the police would see a copy of it, they wanted to dismiss the action. They didn't want to seek the relief because of the fear that it would create this record of the relationship about it. And so I think it has a chilling effect. You know, I wouldn't see it after it left me, whether the person on the other side or anyone else used it as some means of weapon. But I think that the fear of that certainly kept people from accessing help at times.
Excellent. Christopher, how do you keep up on all which scrutiny you're on in all of this? Again, I need a flow chart on which scrutiny I'm looking at.
It's a thing. You know, I've of course read the opinion on a number of occasions, and each time I go back and read it, you know, it's a very comprehensive opinion. It's a long opinion. I pick up on something else here. You know, the equal protection analysis is, you know, relatively straightforward because this is considered by the Court of Appeals, in their opinion, as sex discrimination, and sex discrimination has long a variant of sex discrimination, and sex discrimination has long been treated, based on Justice Ginsburg's work as a litigator, as something that's subject to intermediate scrutiny and really does need a persuasive rationale that's well tailored to that end. I think the due process arguments here are very interesting, that are put forward by Chief Judge McGee, because there's essentially highlighting that there are a number of fundamental rights that are involved, and picking up again on the opinions from Obergefell, where Obergefell, you know, builds on Windsor, builds on Lawrence, builds on Romer, but also builds on Casey, abortion-related litigation, about how individuals do have a constitutional right to, for lack of a better word, organize their intimate affairs and their life according to their dictates when they're not hurting someone else. And the Court of Appeals opinion is, you know, applies strict scrutiny to things that both implicate personal safety, but also implicate those sorts of personal choices. And that, you know, is going to make it very hard to justify restrictions that are classifications that relate to sex discrimination or relate to discrimination based on LGBTQ status. You know, the other thing, and so I think that's one of the, I hesitate to say novel, because a lot of courts have gone through some similar analysis, but it's a very exacting standard that's laid out by the Court of Appeals. But on the flip side, I think it's also important to realize is that what Chief Judge McGee and Judge Bryant say in their opinion is that there's really no rational basis. There's no even imaginable rationale that could justify this exclusion that ME faced in this instance. And that is very much, very directly tied to Justice Kennedy's opinions in all of those cases that I've talked about, where highlighting both that there are historical troubling trends of the LGBTQ community being singled out for negative treatment, but also really asking the question, what possible end can these sorts of exclusions serve? And, you know, coming up with nothing in response to that question.
I find it interesting that 50B was amended after Obergefell in 2015, and yet this problem didn't get corrected in the 50B statute at that time. So can you all address that and discuss that a bit? Why wasn't it corrected? We had the Supreme Court's decision in Obergefell in 2015. We had a time when 50B got amended after that point in time, as I understand it, yet this didn't get addressed. How do we explain that one?
I can give a small and incomplete answer to that question, as I'm not in the legislature myself, but those amendments were not to the personal relationship category itself, but you are correct that 50B has been opened up and changed since Obergefell. I think that's just further evidence that the legislature was not interested in changing this definition until it was explicitly written down in our court's words that it is unconstitutional. But given that I was not kind of in those conversations at that time, and I think that's a question to ask our legislature more than our panel at this point, why that amendment has not been made, even though it feels quite explicitly necessary at this point.
So we have
Carolyn, I'll just add one very brief addendum to that. You know, other states did act after Obergefell to correct these sorts of exclusions. One state that comes to mind right offhand is Louisiana. Had a similar exclusion and took action after Obergefell to ensure that the folks who are in same-sex relationships had equal access to DVPOs.
Great. Okay, audience question was, have the clerk's offices and district court judges been told that they must allow LGBTQ victims to seek DVPOs under ME? Has that been announced to them?
Well,
I like Emily's answer, not to be flip, but you know, you did get the opinion.
Okay.
But having had some experience with court process and where you take legislative changes or appellate changes and then try to, you know, transfer that through hundreds of people. In Guilford, we have 2 fully functioning courthouses, so 2 different cities. You know, it takes some planning and deployment. And so I don't know the answer to that, but I would say that if the opinion came out in December, it's probably something that across the state is in process.
Has the AOC amended the complaint form to reflect the change in the law with ME versus TJ, or will they, or are they waiting on the Supreme Court? Or do any of you know?
The AOC has not amended the forms, even though it sounds quite simple to us, probably in this virtual room. Amending AOC forms is a quite expensive and tedious process. And so it's not unusual that it hasn't happened by March. I don't get the impression that they're waiting on the Supreme Court for this. But no, they have not yet amended the forms, which is why it's even more important for everyone on this call and in the community to be clear about what the state of the law is at this point, since the forms don't reflect that.
Another question from the audience. Much media coverage has suggested prior to this opinion that LGBTQ persons could not get DVPOs at all, but they could if they had lived together. And so I don't know what the media coverage was. I don't remember seeing any, but do any of you know?
I will just clarify that, you know, regardless, the media doesn't always get it right, but that the, you know, correct answer was definitely that prior to this opinion, which clarified that folks could get a DVPO regardless of their household member status or their relationship to their partner, that even prior to that opinion, folks in a same-sex relationship could clearly apply for a 50B as household members if they were current or former household members, or as current or former spouses, even if they were in a same-sex relationship.
Great. So one final wrap up, one sentence from everybody. And then we'll wrap it. Attorney Saint.
It's a lot of pressure, Carolyn.
Okay, well, I don't do that.
I think that the biggest takeaway from this conversation, and Kathleen said it quite well, and so sorry, Kathleen, if I'm stealing your final thoughts, is that, because we are still in a state where folks are learning about this decision, judges are learning about this decision, clerks are learning about this decision, that it's important to take away the arguments from the opinion to use in your practice as you're helping folks seek DVPOs.
Judge Burch.
I think that, the case is still pending in the Supreme Court. And I've long since given up trying to predict anything. But I think that the merit of this opinion in this whole process is what you see in this presentation, is that it highlights this area of the law that is in conflict with our federal law. It shows work that needs to be done. And I think it certainly helps advocates, both legal advocates and advocates just for domestic violence. And I think advocates for just quality of work in our court system as a whole. It shows us areas where we need to be alert to making improvements. And so I think that what happens with the opinion, to me, the benefit of it is already this process.
All right, Ms. Lockwood.
I'll just reemphasize that this court opinion is a really important step in ensuring that all survivors have access to our legal protections. And it's something to be celebrated and also to be implemented. So I'm glad that y'all are here to be a part of that.
Attorney McCool.
Yeah, thanks for being here, everybody. I think having these webinars, thanks for having it, helps get the word out about the fact that this is the law. And I put some resources about trauma-informed lawyering in the chat. And please, if anyone ever has any questions or I can be helpful to you in your practice, please do not hesitate to reach out to me personally.
Attorney Prendergast-Jones.
Thank you again. One of the things that I just want to emphasize is that when you're in your practice and there are issues like this and judges are reluctant to grant anything about the same sex and have any problems with that, we encourage to push forth that this is the law currently and to reach out to one of us if you have any questions, and we're happy to support you. But this is a really powerful thing. And this is important because we want to make sure that all survivors, no matter what their sex is, their gender, any of that, they have these rights. So thank you.
Thank you. And Attorney Brock, you got the final word.
My responsibility here today was talking a little bit about the jurisprudence that was laid out by the Court of Appeals, but I would just underline what everybody else has said. It's obviously jurisprudentially an important decision from the North Carolina Court of Appeals, but far more important than that, underlining what everyone else has said, is that equal access to DVPOs for folks in same-sex relationships is going to save lives. It's going to prevent bad situations from getting worse. And I think that's sort of, I would say, the general thrust of what you've heard from everybody in some way, shape, or form this afternoon.
And thank you to all of the participants today, all of the all-star panelists. You guys we're very thankful for what all of you have done to advance the cause here. And thank you, Judge Burch. It's so good to see you again. And with that, we will all see you next time. Thank you. Bye.